The UCC and U. First edition. A brief overview of commercial law, contracts, and how they may or may not involve you. The material is intended only for educational purposes and does not render any legal, professional, nor financial advice. This educational book is for education only. Things are constantly changing, strive to stay current. Index of contents. Section description. I overview and history of the UCC. 2 definitions and cases with their proper usage. 3 law, contracts, and consent. 4 choice of law, jurisdiction. V perfection, attachment and priority rules. 6 licenses and privileges. 7 UCC and banking. 8 patents and common law trademarks. 9 UCC forms and how they work. X UCC state status and contact information. I overview and history of the UCC. Before you dive into the depths of the Uniform Commercial Code, UCC, I suggest you have some direct and black and white, on-point research materials to help guide you through a complete understanding of the clutches of the UCC. Some of the best books found for this adventure come straight from the American Bar Association itself. Please take time to not only get some of these books but make sure you use them in their entirety for a clear understanding of all terms and applications. There are many books, some of particular interest are: How to order the UCC books from the American Bar. 1. The Portable UCC. 2. The ABCs of the UCC. Article 9. 3. The new Article 9. 4. Default provisions of the revised Article 9. 5. ABCs of the UCC. Article 8. These can be ordered from the American Bar at ABA Publications. P.O. Box 10892, Chicago, Illinois 60610-0892. 1-800-285-2221 toll-free 1-312-988-5568 fax to bar. service@abanet.org. Email to American Bar. Now before we begin the journey, we suggest you have a quick reference to certain section of the code itself. This should help you find certain things based upon their topics. Article 1. General Provisions, 1995, Article 2. Sales, 1995, Article 2A. Leases, 1990, Article 3. Negotiable Instruments, 1991, Article 4. Bank Deposit, 1994, Article 4A. Funds Transfers, 1994, Article 5. Letters of Credit, 1995, Article 6. Bulk Transfers and Revised, Bulk Sales, 1989, Article 7. Warehouse Receipts, Bills of Lading and Other Documents of Title, 1966, Article 8. Investment Securities, 1994, Article 9. Secured Transactions, 1999. Now before you get right into things, there are a couple things one must have a complete understanding of. This takes us back into American history to see what the UCC is itself and where it came from. What the Secretary of State in Michigan says regarding the UCC. UCC Overview http://www.michigan.gov/SOS/0,7-167-127-163-1_885-1-270.HTML. The Uniform Commercial Code law governs commercial transactions. The code includes 11 articles covering a variety of areas such as sales, negotiable instruments, bank deposits and collections, and investment securities. Article 9 of the Uniform Commercial Code, UCC, titled Secured Transactions, designates the Office of the Secretary of State as the place for the filing and searching of secured transaction documents. Financing statements are filed as a public notice of a security interest in collateral. Record searches are requested to reveal financing statements filed against an organization or individual. For example, when a debtor, borrower, pledges collateral to obtain a loan, a UCC financing statement tells a secured party, creditor, whether others have financing statements against the same collateral. Filing a UCC financing statement is a protective measure because it provides a public notice to other parties. Debtors also benefit because the notice system helps them obtain business funding. Legally, it puts the creditor in the position of a secured creditor, and a perfected UCC financing statement may be acted on in case of default. In the event of a bankruptcy proceeding, the creditor will be in a better position to enforce its legal rights. Bit of background and overview how we got here and the way out. The information is compiled right from the UCC code. Right from the latest changes, and from some of the most powerful codes this planet has ever seen. The whole thing started obviously when we had 13 signers to an original Declaration of Independence. That was an underlying contract that was signed by 13 different leaders that said no more. We are done, we are independent from you. We are going to rule ourselves, and that contract led up to another one which is known as the Constitution, and another the Bill of Rights, the Articles of the Confederation, etc., etc., etc. These contracts are what formed a nation here over 200 years ago. It was formed under contract and subformed under codes, rules, and regulations. In 1871 the United States created Act that was called the District of Columbia Organic Act. At that point in time there was only a government and a people, individually based upon the contracts that were written almost 100 years prior to the Constitution, the Articles of Confederation, etc., etc. This new act, called the District of Columbia Organic Act, created the first corporate government that the United States of America has ever seen, and it created a new corporation that most people don't see, let alone believe. Because it's corporate America, it has everything to do with commerce, it's under contract law. Shortly thereafter, they created what is known as the Bureau of Vital Statistics. The Bureau of Vital Statistics is what formed a birth certificate/certificate of title/chattel paper. With the help of the 14th Amendment and the newly created Bureau of Vital Statistics, this birth certificate is what created the first ever in America corporate person known as a straw man, a juristic person, or any other kind of fictitious corporation that you can put in your mind and just think about. It is a fiction, a third-party front, a dummy. It is not you, it is a word that reflects the certificate of title/chattel paper. It's a contract. These contracts enabled the corporate United States to contract with the corporate us. What people have to understand is how they incorporated themselves. They see that one of the biggest problems with some of past or even present information that's out there is a lot of people want to go back to the law. Well, under these contracts that we're speaking of, you became a surety. The surety was responsible to pay for this entire corporation's new existence, such as the Federal Reserve, such as the IRS, such as the Social Security Administration. I hope that everyone out there understands why this corporation is starting to exist and how it came about and how they get to us. They don't deal with us, they deal with our juristic person. The fictional you. Your driver's license, your social security card, most all bills that you get, most anything you get will have your juristic person's name. It's the commerce created by birth certificate and the 14th Amendment citizen name. It is a created U.S. citizen you, not the real flesh and blood you. It is your front. When they started to contract and they switched over our gold, which was in 1933, they took all of the gold and they started using a paper currency, which is a Federal Reserve note, FRN, the dollar bills that we carry around. When they created that new little creature, the corporate America was free to use as much of this paper currency it wanted to. It didn't have to use the gold and silver, so it could just exchange promises from one hand to another. Again, you have to sit back and understand that a corporation is coming after you. There is no Mr. General Motors. General Motors is nobody. It is just a fiction. The information that we've gotten and use is compiled from many years of research, study, trial, and errors. If you look inside the Bill of Rights, most people know we got them, but most people don't understand what it really is or does. You have to stand back and look at the overlying contract. Article 1 through 10 all are a contract for the agents and agencies of the government designed to serve and protect us, and these 10 articles are there to protect us and limit them. Again, it is their contract, not ours. It is their agreement, under oath, not our rights. Our rights come from the highest power, not any secular government. So what the UCC does is actually goes in, it allows you to take those contracts and make a claim against the listed properties. Once you have made a claim, you have an interest in the property, and now consideration needs to be made in order for you to lose your priority in that interest. Or in other words, they have to buy an interest in order to gain a priority. Of course, you could just rescind all documents as well, but please understand this study course before trial by error occurs for you. Consent is the largest issue in contract law. It's something that has worked in all levels, it works everywhere because it is the law. Law is defined as a rule or regulation from a government to its citizens. When you look into a consensual encounter, or voluntary compliance, the first thing that happens when you get pulled over, for instance, what happens to you? What do they do? What's the first thing they ask you for? Can I see your driver's license, registration? Or can I see your papers? They are asking you to voluntarily give them their papers, agreements, so that they can charge you. Why? Because they own the contract and they can do that by your agreement to the contract. You signed that driver license, correct? You paid for the license, correct? You didn't know it, but you turned all your rights into certain privileges and you went in and asked them for it and paid them for it, and they have the proof of it simply by seeing your state of ________ driver license. The Fourth Amendment is about consent. And the Fourth Amendment is probably the most powerful amendment, powerful law, and powerful set of words in law. If you have anything that you would like to study on, it should be the Fourth Amendment. Brown versus TX. Ask yourself this question after reading it. Does it grant any rights or does it impose a liability? After asking this, ask yourself, to whom does this liability hold to? You or the sworn agents under oath? Consent. I do not agree or consent. What they are doing to you is that they as a corporation are coming up to you as a corporation and asking you to contract with them. They have no evidence, nor can they deal with anything but that fiction. I'm sorry, I don't want to do business with you. And the information works because of the way that the code is set up. It enables you to make claims on your property. That's what the UCC is. So many people that I talked to in the past have said, you file your UCC and your problems will go away. That is so far from the truth. I don't even want to comment any further than that. A UCC is an asset protector and it allows you to register certain property that you are making a claim upon. That is what it is. If there is no claim, you can't claim back on it. So right now, up until this point, if you're new to this, you didn't understand any of what was just said, but it's starting to become clear to you now, as though it's a corporation against a corporation, and you have to step back behind the scene there and realize that the IRS, the state of ____________, the United States, are all fictions coming after you. They don't exist other than in your mind and in your agreement. You can't call Mr. IRS to the stand in a courtroom. He won't show up. We've been looking for him for years. We can't find him. We've been looking for another guy called Society for quite some time, but we can't find him either. They don't exist. So, if they don't exist, then they can't make the claim on the property. You can though, once you make a proper claim, get a claim in there. If anyone was to try to infiltrate your property, now you have stated a claim, in which relief can be granted. You now hold a superior claim. Do you really think they will say they are entitled to your name? Just a synopsis: there is a corporate government and a real government, and they have created a fictional you, which is known as a juristic person. And this corporate government is doing just what McDonald's is doing when you pull up to McDonald's. May I help you? Sure, I'll take a number 3 with a Coke. Okay, that will cost you $5.14. They are conducting business with you. And you have the right, every state citizen has this right, to where you can or cannot, it's your option, to conduct business with whomever you wish to. If you don't wish to do business with somebody, you don't have to. No one can force you to. It is the same concept. It's just we set our groundwork and do our claim ahead of time. That way it will minimize chances of an issue. Test for you. Send a FOIA to an attorney general and ask them if any corporation can compel you to do business with them. When they tell you no, send another asking if the USA, IRS, state of ________ operates under commerce. See your response, or they're sidestepping the question. Seems like an easy question, so if they resist, then you may have something. Now for some history on this topic from the legal end. If this, in 1950, or so, some major change took place in the way government came about. This may have been in response to the 1948 Judiciary Act that created the USDCs. On July 31, 1945. Pursuant to I. 817 and 4. 3:2, Congress passed the District of Columbia Organic Act on February 21, 1871, Chapter 62, 16 Stat. 419, forming the corporation known as District of Columbia. This corporation was reorganized June 11, 1878, Chapter 180, 20 Stat 102, and renamed United States Government, and it trademarked the names United States, U.S., U.S.A., USA, and America. The states of the Union all organized as corporations only much later, between 1962 and 1968. Look for the Administrative Organization Act or some such in your state. These acts created corporations known as state of underscore 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 underscore. This corporation was charged with the responsibility of carrying out the business needs of the national government. This harkens back to a discussion I read earlier on suing the sovereign when it is not the sovereign being sued. It issued bonds to cover its expenses until 1912, when there were more bonds due than there was money of account in the treasury to pay for the bonds. It was the banking families who had bought up these bonds, and they became due and payable. The corporation asked these banking families if they could borrow the money to pay for the bonds, and the families refused. Instead, provisions were made to fund the corporation, but not the government, with securities issued against monies held by the banking families. This occurred on Jekyll Island, Georgia in 1913. These securities were known as Federal Reserve Notes. Even though the government could not sign this contract, the corporation could and did. This was a private contract between private corporations. We can skip the Trading with the Enemy Act of 1917 and the Emergency War Powers Act of 1933, which are important, but not for the purposes of this discussion. Which brings us to the Act of July 31, 1945, ch. 339, Sector 2, 59 Stat 512. 22 U.S.C. 286. Acceptance of membership by United States in International Monetary Fund. The President is hereby authorized to accept membership for the United States in the International Monetary Fund, hereinafter referred to as the Fund, and in the International Bank for Reconstruction and Development, hereinafter referred to as the Bank, provided for by the Articles of Agreement of the Fund and the Articles of Agreement of the Bank as set forth in the Final Act of the United Nations Monetary and Financial Conference dated July 22, 1944, and deposited in the archives of the Department of State. July 31, 1945, ch. 339, Sector 2, 59 Stat 512. Notes on Title 22, Section 286. Source, July 31, 1945, ch. 339, Sector 2, 59 Stat 512. Short title of 1968 Amendment Publ 90-349, June 19, 1968, 82 Stat 188, enacting Sections 286 and 286R of this title and amending Sections 412, 415, 417, and 467 of Title 12, Banks and Banking, is known as the Special Drawing Rights Act. For complete classification of this act to the Code, see short title note set out under Section 286N of this title and tables. Short title Section 1 of Act July 31, 1945, provided, this Act, enacting this subchapter and amending Section 822 of former Title 31, Money and Finance, may be cited as the Bretton Woods Agreements Act. PAR value modification for congressional direction that the Secretary of the Treasury maintain the value in terms of gold of the holdings in United States dollars of the International Monetary Fund and of the International Bank for Reconstruction and Development following the establishment of a PAR value of the dollar at $38 for a fine troy ounce of gold pursuant to the PAR Value Modification Act and for the authorization of the appropriation necessary to provide such maintenance of value, see Section 5152 of Title 31, Money and Finance. Cross-references advancement of human rights through United States assistance policies with international financial institutions, see Section 262D of this title. Increase in lending authority of the Export-Import Bank of Washington, see Section 635 to 635H of Title 12, Banks and Banking. United States membership in the United Nations Food and Agriculture Organization, see Sections 279 to 279D of this title. And Sector 286N. Special Drawing Rights. The President is hereby authorized, a. to accept the amendment to the Articles of Agreement of the International Monetary Fund, hereinafter referred to as the Fund, attached to the April 1968 report by the Executive Directors to the Board of Governors of the Fund, for the purpose of, I. establishing a facility based on special drawing rights in the Fund and, 2. giving effect to certain modifications in the present rules and practices of the Fund, and, b. to participate in the special drawing account established by the amendment. 22 U.S.C. 611 Sector 611. Definitions as used in and for the purposes of this subchapter. A. The term person includes an individual, partnership, association, corporation, organization, or any other combination of individuals. b. The term foreign principal includes 1. A government of a foreign country and a foreign political party. 2. SNP. 3. A partnership, association, corporation, organization, or other combination of persons organized under the laws of or having its principal place of business in a foreign country. C. Expect 1 as provided in subsection D of this section. The term agent of a foreign principal means 1. So in original. Probably should be except 1. Any person who acts as an agent, representative, employee, or servant, or any person who acts in any other capacity at the order, request, or under the direction or control of a foreign principal or of a person any of whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized in whole or in major part by a foreign principal, and who directly or through any other person I. Engages within the United States in political activities for or in the interests of such foreign principal. 2. Acts within the United States as a public relations counsel, publicity agent, information service employee, or political consultant for or in the interests of such foreign principal. 3. Within the United States solicits, collects, disperses, or dispenses contributions, loans, money, or other things of value for or in the interest of such foreign principal, or 4. Within the United States represents the interests of such foreign principal before any agency or official of the government of the United States, and 2. Any person who agrees, consents, assumes, or purports to act as, or who is or holds himself out to be, whether or not pursuant to contractual relationship, an agent of a foreign principal as defined in Clause 1 of this subsection. June 8, 1938, ch. 327, Sector 1, 52 Stat 631. Wouldn't that make the Secretary an agent for a foreign principal? Sector 219. Officers and employees. Acting as agents of foreign principals. Now that you have a general idea, it is time to cross-reference the state, or should I say states. The United States Code, I believe in Title 12 describing jurisdiction, states that federal jurisdiction ends at the state borders, 3 miles offshore, and is over federal lands within the state boundaries. We living outside D.C., Samoa, U.S. Virgin Islands, Marianas Islands, are not within federal jurisdiction. Now let's take a look at 1 U.S.C. Chapter 3 Section 204. Sector 204. Codes and Supplements as evidence of the laws of United States and District of Columbia, citation of codes and supplements in all courts, tribunals, and public offices of the United States, at home or abroad, of the District of Columbia, and of each state, territory, or insular possession of the United States. A. United States Code. The matter set forth in the edition of the Code of Laws of the United States current at any time shall, together with the then current supplement, if any, establish prima facie the laws of the United States, general and permanent in their nature, in force on the day preceding the commencement of the session following the last session, the legislation of which is included, provided, however, that whenever titles of such code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained, in all the courts of the United States, the several states, and the territories and insular possessions of the United States. Notice the word of is highlighted above. According to Black's Law Dictionary, the term of means indicating origin, source, associated with or connected with, usually in some casual relation, efficient, material, formal, or final. Now if the United States is defined as a federal corporation and of means connected with, now 1 U.S.C. Sector 204 in their defined words really means, see 28 U.S.C. 3001, 15, for United States defined. Sector 204. Codes and Supplements as evidence of the laws of, federal corporation, citation of codes and supplements in all courts, tribunals, and public offices, connected with, the, federal corporation, at home or abroad, of the, federal corporation, and of each state, territory, or insular possession, connected with, the, federal corporation. A. United States Code. The matter set forth in the edition of the Code of Laws of the, Federal Corporation, current at any time shall, together with the then current supplement, if any, establish prima facie the laws of the, Federal Corporation, general and permanent in their nature, in force on the day preceding the commencement of the session following the last session, the legislation of which is included, provided, however, that whenever titles of such code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained, in all the courts, connected with the federal corporation, the several states, and the territories and insular possessions, connected with the federal corporation. The Story of the Buck Act. By Richard MacDonald, edited by Mitch Modlisky. In order for you to understand the full import of what is happening, I must explain certain laws to you. When passing new statutes, the federal government always does everything according to the principles of law. In order for the federal government to tax a citizen of one of the several states, they had to create some sort of contractual nexus. This contractual nexus is the Social Security number. In 1935, the federal government instituted Social Security. The Social Security Board then created 10 Social Security districts. The combination of these districts resulted in a federal area which covered all the several states like a clear plastic overlay. In 1939, the federal government instituted the Public Salary Tax Act of 1939. This act is a municipal law of the District of Columbia for taxing all federal and state government employees and those who live and work in any federal area. Now, the government knows it cannot tax those state citizens who live and work outside the territorial jurisdiction of Article 1, Section 8, Clause 17, 1:8:17, or Article 4, Section 3, Clause 2, 4:3:2, in the U.S. Constitution. So, in 1940, Congress passed the Buck Act, for USCS Sections 105 to 113. In Section 110(e), this act authorized any department of the federal government to create a federal area for imposition of the Public Salary Tax Act of 1939. This tax is imposed at 4 USCS Sector 111. The rest of the taxing law is found in the Internal Revenue Code. The Social Security Board had already created a federal area overlay. 4 USCS Sector 110(d). The term state includes any territory or possession of the United States. 4 USCS Sector 110(e). The term federal area means any lands or premises held or acquired by or for the use of the United States or any department, establishment, or agency of the United States, and any federal area, or any part thereof, which is located within the exterior boundaries of any state, shall be deemed to be a federal area located within such state. There is no reasonable doubt that the federal state is imposing an excise tax under the provisions of 4 USCS Section 105, which states in pertinent part, Sector 105. State, and so forth, taxation affecting federal areas, sales or use tax. A. No person shall be relieved from liability for payment of, collection of, or accounting for any sales or use tax levied by any state, or by any duly constituted taxing authority therein, having jurisdiction to levy such tax, on the ground that the sale or use, with respect to which such tax is levied, occurred in whole or in part within a federal area, and such state or taxing authority shall have full jurisdiction and power to levy and collect any such tax in any federal area within such state to the same extent and with the same effect as though such area was not a federal area. Irrespective of what the tax is called, if its purpose is to produce revenue, it is an income tax or a receipts tax under the Buck Act for USCASECS 105 to 110. Humble Oil and Refining Co. v. Calvert, 464 SW2D. 170, 1971, aft, Tex, 478 SW2D. 926, Cert. Den. 409 US 967, 34 L.ed. 2D 234, 93 S.ct 293. Thus, the obvious question arises, what is a federal area? A federal area is any area designated by any agency, department, or establishment of the federal government. This includes the Social Security areas designated by the Social Security Administration, any public housing area that has federal funding, a home that has a federal bank loan, a road that has federal funding, and almost everything that the federal government touches through any type of aid. Springfield v. Kenny, 104 NE2D 65, 1951 App. This federal area attaches to anyone who has a Social Security number or any personal contact with the federal or state governments. Through this mechanism, the federal government usurped the sovereignty of the people, as well as the sovereignty of the several states, by creating federal areas within the boundaries of the states under the authority of Article 4, Section 3, Clause 2, 4:3:2, in the federal constitution, which states, 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States, or of any particular state. Therefore, all U.S. citizens, i.e. citizens of the District of Columbia residing in one of the states of the Union, are classified as property, as franchisees of the federal government, and as an individual entity. See Wheeling Steel Corp v. Fox, 298 U.S. 193, 80 L.ed. 1143, 56 S.ct. 773. Under the Buck Act, 4. U.S.C.S. SECS 105 to 113, the federal government has created a federal area within the boundaries of all the several states. This area is similar to any territory that the federal government acquires through purchase, conquest, or treaty, thereby imposing federal territorial law upon all people in this federal area. Federal territorial law is evidenced by the executive branch's yellow-fringed U.S. flag flying in schools, offices, and all courtrooms. You must live on land in one of the states in the Union of several states, not in any federal state or federal area, nor can you be involved in any activity that would make you subject to federal laws. You cannot have a valid social security number, a resident driver's license, a motor vehicle registered in your name, a federal bank account, a Federal Register account number relating to individual persons SSN, see Executive Order No. 9397, November 1943, or any other known contract implied in fact that would place you within any federal area and thus within the territorial jurisdiction of the municipal laws of Congress. Remember, all acts of Congress are territorial in nature and only apply within the territorial jurisdiction of Congress. See American Banana Co. v. United Fruit Co., 213 U.S. 347, 356 to 357, 1909, U.S. v. Spiller, 338 U.S. 217, 222, 94 L.ed. 3, 70 S.ct. 10, 1949, New York Central R.R. Co. v. Chisholm, 268 U.S. 29, 31 to 32, 69 L.ed. 828, 45 S.ct. 402, 1925. There has been created a fictional federal state within a state. See Howard v. Sinking Fund of Louisville, 344 U.S. 624, 73 S.ct. 465, 476, 97 L.ed. 617, 1953, Schwartz v. O'Hara TP School DIST, 100 A2D. 621, 625, 375 PA 440. Compare also 31 CFR Parts 51.2 and 52.2, which also identify a fictional state within a state. This fictional state is identified by the use of two-letter abbreviations like CA, AZ, and TX, as distinguished from the authorized abbreviations like California, Arizona, and Texas, etc. This fictional state also uses zip codes which are within the municipal, exclusive legislative jurisdiction of Congress. This entire scheme was accomplished by passage of the Buck Act, 4 U.S.C.S. SECS 105 to 113, to implement the application of the Public Salary Tax Act of 1939 to workers within the private sector. This subjects all private sector workers who have a Social Security number to all state and federal laws within this state, a fictional federal area overlaying the land in California and in all other states in the Union. In California, this is established by California Form 590, Revenue and Taxation. All you have to do is to state that you live in California. This establishes that you do not live in a federal area and that you are exempt from the Public Salary Tax Act of 1939 and also from the California income tax for residents who live in the state. The following definition is used throughout the several states in the application of their municipal laws which require some sort of contract for proper application. This definition is also included in all the codes of California, Nevada, Arizona, Utah, and New York. In this state or in the state means within the exterior limits of the state, and includes all territories within such limits owned or ceded to the United States of America. Please remember the United States is corporate, thus state is a subcorporation of the corporation. This definition concurs with the Buck Act Super, which states, 110, d, the term state includes any territory or possession of the United States. 110, e, The term federal area means any lands or premises held or acquired by or for the use of the United States or any department, establishment, or agency of the United States, and any federal area, or any part thereof, which is located within the exterior boundaries of any state, shall be deemed to be a federal area located within such state. So, do some research. I have given you all the proper directions in which to look for the jurisdictional nexus that places you within the purview of the federal government. So now it all kind of makes sense, right? Well, if not, I trust the graph on the next page shows you how the mechanics works. Memorandum of Law on the name author unknown. Many people are involved in diligent research concerning the use of all capital letters for proper names, example John Paul Jones as a substitute for John Paul Jones in all court documents, driver's licenses, bank accounts, birth certificates, etc. Is the use of all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official judicial or U.S. government rule and/or style of grammar? Why do attorneys, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What English grammar experts say. One of the foremost authorities on American English grammar, style, composition, and rules is the Chicago Manual of Style. The latest, 14th, edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. Since we can find no reference in their manual concerning the use of all capitalized letters with a proper name or any other usage, we wrote to the editors and asked this question. Is it acceptable, or is there any rule of English grammar, to allow a proper name to be written in all capital letters? For example, if my name was John Paul Jones, can it be written as John Paul Jones? Is there any rule covering this? The editorial staff of the University of Chicago answered. Writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wind appears on the title page all in caps, we would properly render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We're not sure in what context you would like your proper name to appear in all caps, but it is likely to be seen as a bit odd. Law is extremely precise. Every letter, capitalization, punctuation mark, etc., in a legal document is utilized for a specific reason and has legal, i.e. deadly force, consequences. If, for instance, one attempts to file articles of incorporation in the office of a Secretary of State of a state, if the exact title of the corporation down to every jot and tittle, is not exactly the same each and every time the corporation is referenced in the documents to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid, and possibly crucial, question as to why governments, governmental courts, and agencies purporting to exist, in some undefined, unproved manner, within the jurisdiction of the state insist on always capitalizing every letter in a proper name. Mary Newton Bruder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question. Why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is John Paul Jones, is it proper at any time to write my name as John Paul Jones? Dr. Bruder's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps, so we began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer. What English grammar reference books say? Manual on Usage and Style. One of the reference books obtained was the Manual on Usage and Style, 8th edition, ISBN I-878-674-51-X, published by the Texas Law Review in 1995. Section D, Capitalization, Paragraph D, 1:1 states. Always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things, example Dan, Austin, Rolls-Royce. Paragraph D, 3:2 of Section D states. Capitalize people, state, and any other terms used to refer to the government as a litigant, example the people's case, the state's argument, but do not capitalize other words used to refer to litigants, example the plaintiff, defendant Manson. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law is no excuse, or violation. One violating the law he enforces on others is acting under title of nobility and abrogating the principle of equality under the law of law. They continue to write plaintiff, defendant, the state of Texas and proper names of parties in all capital letters on every court document. The Elements of Style. Another well-recognized reference book is The Elements of Style, 4th edition, ISBN 0205-30902-X, written by William Strunk, Jr., and E. B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book, is found only one reference to capitalization, located within the glossary at proper noun, page 94, where it states: the name of a particular person, Frank Sinatra, place, Boston, or thing, Moby Dick. Proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a practical and authoritative guide to contemporary English, published in 1996, at Chapter 9, Email, Conventions and Quirks, Informality, states: to give a message special emphasis, an emailer may write entirely in capital letters, a device emailers refer to as screaming. Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limit many networks. Here is a reference source, within contemporary modern English, that states it is of an informal manner to write every word of, specifically an electronic message, aka email, in capital letters. They say it's screaming to do so. By standard definition, we presume that is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum of a court if everyone is yelling? Is the insurance company screaming at us for paying the increased premium on our policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys and the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English. The New Oxford Dictionary of English is published by the Oxford University Press. Besides being considered the foremost authority on the British English language, this dictionary is also designed to reflect the way language is used today through example sentences and phrases. We submit the following definitions from the 1998 edition. Proper noun, also proper name. Noun. A name used for an individual person, place, or organization, spelled with an initial capital letter, e.g. Jane, London, and Oxfam. Name. Noun. 1. A word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parsons, John Parsons. Kochwasser is the German name for lime water. Verb. To identify by name, give the correct name for, the dead man has been named as John Macintosh. Phrases. 3. In the name of. Bearing or using the name of a specified person or organization, a driving license in the name of William Sanders. From the Newberry House Dictionary of American English, published by Monroe Allen Publishers Incorporated, 1999. Name N. I see a word by which a person, place, or thing is known. Her name is Diane Daniel. We can find absolutely no example in any recognized reference book that specifies or allows the use of all capitalized names, proper or common. There is no doubt that a proper name, to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters. U.S. Government Style Manual. Is the spelling and usage of a proper name defined officially by U.S. government? Yes. The United States Government Printing Office in their Style Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writing. Chapter 3, Capitalization, at 3.2, prescribes rules for proper names. Proper names are capitalized. Examples given are Rome, Brussels, John Macadam, Macadam. Family, Italy, Anglo-Saxon. At Chapter 17, Court Work, the rules of capitalization, as mentioned in Chapter 3, are further reiterated. 17.1. Court work differs in style from other work only as set forth in the section, otherwise the style prescribed in the preceding sections will be followed. After reading 17 in entirety, I found no other references that would change the grammatical rules and styles specified in Chapter 3 pertaining to capitalization. At 17.9, this same official U.S. government manual states, in the titles of cases the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This wholly agrees with Texas Law Review's Manual on Usage and Style as referenced above. Examples shown in 17.12 are also consistent with the aforementioned 17.9 specification, that is, all proper names are to be spelled with capital first letters, the balance of each spelled with lowercase letters. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, NASA, has published one of the most concise U.S. government resources on capitalization. NASA publication SP 7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. At Chapter 4, Capitalization, they state in 4.1 Introduction. First, we should define terms used when discussing capitalization. All caps means that every letter in an expression is capital, like this. Caps and 1C means that the principal words of an expression are capitalized, like this. Caps and small caps refer to a particular font of type containing small capital letters instead of lowercase letters. Elements in a document such as headings, titles, and captions may be capitalized in either sentence style or headline style. Sentence style calls for capitalization of the first letter, and proper nouns of course. Headline style calls for capitalization of all principal words, also called caps and LC. Modern publishers tend toward a down style of capitalization, that is, toward use of fewer capitals, rather than an up style. Here we see that in headlines, titles, captions, and in sentences, there is no authorized usage of all caps. At 4.4.1, Capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are always formed with capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing systems combine what you see is what you get. WYSIWYG, features. Correct. The best electronic publishing systems combine what you see is what you get. WYSIWYG, features. But Langley is involved with the National Aerospace Plane, NASP, program. This cites, by example, that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so that definition is required. Could this apply to lawful proper Christian names? If that were true, then John Smith would have to follow a definition of some sort, which it does not. For example, only if John Smith were defined as John Orley Holistic Nutrition of the Smith Medical Institute to Holistics, John Smith, would this apply. The most significant section appears at 4.5, Administrative names. Official designations of political divisions and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States Northwest Territories, Virgin Islands, Ontario Province. Names of governmental units: U.S. Government Executive Department, U.S. Congress, U.S. Army, U.S. Navy. According to this official U.S. government publication, the states are never to be spelled in all caps such as New York State. The proper English grammar and legal style is New York State. This agrees, once again, with Texas law. Review's Manual on Usage and Style. The use of a legal fiction. The Real-Life Dictionary of the Law. The authors of the Real-Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction. A presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage, fictions arise from the law, and not law from fictions. Oron's Dictionary of the Law. From Oron's Dictionary of the Law, published by the West Group 1999, within the definition of fiction is found. A legal fiction is an assumption that something that is, or may be, false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of Law 1996 states: legal fiction. Something assumed in law to be fact irrespective of the truth or accuracy of that assumption. Example: the legal fiction that a day has no fraction Fields versus Fairbanks North Star Borough, 818p.2 D658, 1991. This is the reason behind the use of all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entity in all caps, they are legally stating that it is also intended to be a legal fiction. As stated by Dr. Mary Newton Bruder in the beginning of this memorandum, the use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to a legal fiction is assumption as noted in each definition above. Conclusion: there are no official or unofficial English grammar style manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by fiat, within and out of an undisclosed jurisdiction by unknown people for unrevealed reasons, by juristic license of arbitrary presumption not based on fact. The authors of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit. Assumption of a legal fiction. An important issue concerning this entire matter is whether or not a proper name, perverted into an all-caps assemblage of letters, can be substituted for a lawful Christian name or any proper name, such as the state of Florida. Is the assertion of all capital letter names legal? If so, from where does this practice originate and what enforces it? A legal fiction may be employed when the name of a person is not known, and therefore using the fictitious name John Doe as a tentative, or interim artifice to surmount the absence of true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. It is an acceptance with no proof. Simply, to assume is to pretend. Oron's Dictionary of the Law says that the word assume means 1. To take up or take responsibility for, to receive, to undertake. See assumption. 2. To pretend. 3. To accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meanings of the second and third definitions with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive, or assumption, does not have the same meaning. Oron's defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the word assume are combined? In a literal and definitive sense, the meanings of assume would be the pretended acceptance, without proof, that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of the legal fiction John P. Jones in place of the proper name John Paul Jones implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong it is considered valid. An assumed debt is valid unless proven otherwise. an unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps, resembling a proper name but grammatically not a proper name, is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, i.e. John Paul Jones, answers for or assumes the fabricated name, i.e. John P. Jones? The two become one and the same. This is the crux for the use of the all-caps names by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas or John Doe in their courts or on driver's licenses? What stops them from doing this? Obviously, there is a reason for using the all-caps names, since they are very capable of writing proper names just as their own official style manual states. The reason behind legal fictions is found within the definitions as cited above. The legalities of all capital letters names. We could go on for hundreds of pages citing the legal basis behind the creation and use of all capital letters names. In a nutshell, fabricated legal persons such as State of Texas can be used to fabricate additional legal persons. Fictions arise from the law, not the law from fictions. Bastard legal persons originate from any judicial/governmental actor that wishes to create them, regardless of whether he/she/it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation-states, all of which are artificial, corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation-states of that treaty. Representatives of the people in each nation-state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to the lawful process or created outside of lawful process? Executive orders and directives. For years many have researched the lawful basis for creating all-caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all: executive orders and directives. They are color of law without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code, rules, and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln establishes executive orders. 85 years after the independence of the United States, 7 southern nation-states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost and Congress was adjourned sine die, or without day. This meant that there was no lawful quorum to set a specific day and time to reconvene which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority, or lawful due process, of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more meritorious than so what are you going to do about it? Having a monopoly on the currency, law, and what passes for government, and most of the world's firepower, the motto of the powers that be is, we've got what it takes to take what you've got. Legal fiction laws, such as the Reconstruction Acts and the implementation of the Lieber Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on colorable fictitious entities created arbitrarily, out of nothing, without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules of rulership by force/conquest, originating from and existing in military, martial law jurisdiction. Military, martial law jurisdiction, jurisdiction of war, win/lose interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy or avoid being eaten, killed, or destroyed, no law, lawlessness. Complete absence of all lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity, no lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence, no bona fide, enforceable contract, no valid, enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demands from self-admitted outlaws committing naked criminal aggression without any credibility and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military, martial law jurisdiction with the only law being the law of necessity, i.e. the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win/lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins, now, therefore, I, Harry S. Truman, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5b of the Trading with the Enemy Act of October 6, 1917, 40 Stat 415, as amended, Section 5b of Appendix to Title 50, and Section 4 of the Act of March 9, 1933, 48 Stat 2. Sic transit rights, substance, truth, justice, peace, and freedom in America, the land of the free and the home of the brave. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law. In this country, the law in effect in all but a few states until mid-19th century was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe v. Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e., executive orders and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida Statutes, 1999, Title I Chapter 2, at 2.01 Common Law and certain statutes declared in force, it states: the common and statute laws of England which are of a general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be of force in the state, provided, the said statutes and common law be not inconsistent with the Constitution and laws of the United States and the acts of the legislature of the state. History. S.L., November 6, 1829, Rs. 59, Gs. 59, Rgs. 71, CGL 87. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes based on executive order and not the due process specified within the organic Constitution. Existing and functioning under the law of necessity ab initio, they are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e. organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any results other than disruption, conflict, damage, and devastation. The established maxim of law applies. Extraterritorium jus dicenti non peritur impun. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. 10 Co 77, Dig. 2-1. 20, Story, Conflow. Laws 539, Broom, Max 100, 101. Applying it all to current laws. An established maxim of law states the importance of the name. Ad rectosendum portet, primum inquire nomina, qui rerum cognitio a nominibus rerum dependet. In order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Colit. 68. Title 3, Pleadings and Motions, Rule 9, A, Capacity, Federal/State Rules of Civil Procedure, states, in pertinent part. When an issue is raised as to the legal existence of a named party, or the party's capacity to be sued, or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. Rule 9, A, Federal/State Rules of Civil Procedure, Title 28 U.S.C. Appendix, Unstatutory, see Statutory Title 1 U.S.C. 204, Notes. At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement correction, for all parties of an action of purported law. However, the current courts cannot correct this, since they are all based on presumed/assumed fictional law and must use artificial, juristic names. Instead, they expect the lawful Christian man or woman to accept the all-caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder/enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumption that you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all-caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma statutes, Chapter 22, 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. Legal definition. In fact, it would appear that the Oklahoma statutes are saying that the use of a fictitious name in either an indictment or information, prosecutorial, that such use is forgivable upon after-the-fact correction. Unfortunately, that is not the case when held to legal definition. Fictitious name. A counterfeit, alias, feigned, or pretended name taken by a person, differing in some essential particular from his true name, consisting of Christian name and patronymic surname, with the implication that it is meant to deceive or mislead. Black's Law Dictionary, 6th ed. pg 624. The use of, by implication, mistake, or otherwise, of fictitious names within any lawful and even legal document renders said document/instrument fatally flawed for simple fraud. And, since no private citizen can be held accountable for the same crime twice, by guarantee, then if initially one is charged in the wrong name, and that mistaken identity at any stage of the proceeding renders the present proceeding null, void, and dismissed. This renders the above statute also null, void, and never written, for this fatal error cannot be corrected, and one must, secondly, face the same charges. Mistaken identity cannot be used as a correctable error merely because one cannot be charged twice for the same cause, even if the first charged was mistaken. But that is not the limit of legal definition of fictitious use of names. It is much more serious to use a fictitious name as a plaintiff. Fictitious plaintiff. A person appearing in the writ, complaint, or record as the plaintiff in a suit, but who in reality does not exist, or who is ignorant of the suit and of the use of his name in it. It is a contempt of court to sue in the name of a fictitious party. Black's Law Dictionary, 6th ed. pg 624. Obviously, any action in which both and/or all parties are fictitious is a fictitious action, and it is legally defined as such: fictitious action. An action brought for the sole purpose of obtaining the opinion of the court on a point of law, not for the settlement of any actual controversy between the parties. Black's Law Dictionary, 6th ed. pg 624. These three legal definitions have now led us to one final definition that defines any and all such fictitious actions: fictitious. Founded on a fiction, having the character of a fiction, pretended, counterfeit. Feigned, imaginary, not real, false, not genuine, non-existent. Arbitrarily invented and set up, to accomplish an ulterior object. Black's Law Dictionary, 6th ed. pg 624. It does not take a rocket scientist to figure out many of these ulterior objects: constitutional abrogation, tyranny, despotism, false personation, embezzlement of the public money, banking fraud, commercial fraud, identity theft, neglect of office, malfeasance, misfeasance and nonfeasance of office, piracy, privateering, kidnapping, false imprisonment, ransoming, constitutional malpractice, maritime fraud, military fraud, trademark infringement/counterfeiting, anti-Christian acts, securities fraud, communism, fascism, alien enemy program, etc. The list is almost endless. It appears, thus far, that legal definition of these fictitious/legal fiction/imaginary/etc. assumptive/presumptive has far and away been the most damaging references used to the cause and case of the tyrants and despots that are so prevalent. American jurisprudence. In general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what, and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2d, at Judgments. 100 parties, a judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the persons for and against whom the judgment is rendered. Technical deficiencies in the naming of the persons for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnote numbers and cites are omitted. The present situation in America. A legal person equals a legal fiction. One of the terms used predominantly by the present civil governments and courts in America is legal person. Just what is a legal person? Some definitions are: a legal person, a body of persons or an entity, as a corporation, considered as having many of the rights and responsibilities of a natural person and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person. I, a human being, a natural person. 2, a corporation, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporations in most definitions in this dictionary. 3, any other being entitled to sue as a legal entity, a government, an association, a group of trustees, etc. 4, the plural of person is persons, not people, see that word. Oron's Dictionary of the Law, West Group, 1999. Person. An entity with legal rights and existence including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court either by themselves or by lawyer and, generally, other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity such as a court finding of mental incapacity. Many laws give certain powers to persons which, in almost all instances, includes business organizations that have been formally registered such as partnerships, corporations, or associations. Duime's Law Dictionary. Person, noun. Per sn. Latin persona, said to be compounded of per, through, or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. 8. In law, an artificial person is a corporation or body politic. Blackstone. Webster's 1828 Dictionary. A sovereign is not a person. United Mine Workers vs. United States, 330 U.S. 258. A name is word or words used to distinguish and identify a person. Name, 65 CJS 1, PG 1. Person. It may include limited to artificial beings, as corporations, territorial corporations, foreign corporations, relating to taxation and revenue laws. 14. Amendment persons. A county, a slave, estate of a decedent, a judge holding court, an infant ward of the court, officers, partnerships, and women, participants in the forbidden acts, defendants and plaintiffs, agents, officers, and members of the board of directors or trustees, or their controlling bodies, of corporations, the legal subject matter or substance rem, res. Bouvier's Law Dictionary, 8th ed., pg 2574. A corporation incorporated under de jure law, i.e. by bona fide express contract between real beings capable of contracting, is a legal fact. Using the juristic artifice of presumption, or assumption, a device known as a legal fiction, implied contract, constructive trusts, another entirely separate entity can be created using the name of the bona fide corporate legal fact, the name of the corporation, by altering the name of the corporation into some other corrupted format, such as all capital letters or abbreviated words in the name. The corporation exists in law, but has arbitrarily been assigned another name. No such corporation, legal fact, nor any valid law, nor even a valid legal fiction, can be created under the law of necessity, i.e. under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption, over unwary, uninformed, and usually blindly trusting people, can be legitimately exercised under no law. Anything whatsoever done under alleged authority of naked criminal aggression, i.e. law of necessity, can be rendered legitimate. Maxims of law describing necessity include: necessity has no law. Plowed. 18, and 15 Venn. Abridged 534, 22 ID 540. In time of war, laws are silent. Cicero. Non-existent law, the legal condition that universally prevails in the official systems of the world today, means that no lawful basis exists upon which anything can be created, or be made to transpire, upon which basis allegiance and obedience can be legitimately demanded. Acting under the law of necessity, i.e. lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor, and con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law and it is impossible for an attorney or judge to recognize or access it, you are not, and cannot be made subject to by them, in their jurisdiction. The crucial issue is then how to notice them of your position and standing. A person created under de jure law, with the person's identifying name appearing as prescribed by law and according to the rules of English grammar, is a legal fact. A corrupted alter ego version of that name, manufactured under the legal fiction of right of presumption, will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful. It is crucial to define the difference between legal and lawful. The generic Constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meanings? The following is quoted from a Dictionary of Law, 1893. Lawful. In accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing conformable to or enjoined by law. Legal, a thing in the form or after the manner of law or binding by law. A writ or warrant issuing from any court, under color of law, is a legal process however defective. See legal. Legal. Latin legalis. Pertaining to the understanding, the exposition, the administration, the science, and the practice of law, as, the legal profession, legal advice, legal blanks, newspaper. Implied or imputed in law. Opposed to actual legal looks more to the letter form/appearance, and lawful to the spirit substance/content, of the law. Legal is more appropriate for conformity to positive rules of law, lawful for accord with ethical principle. Legal imports rather that the forms appearances of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed, lawful that the right is actful in substance, that moral quality is secured. Legal is the antithesis of equitable, and the equivalent of constructive. 2 Abbott's Law Dictionary 24. Legal matters administrate, conform to, and follow rules. They are equitable in nature and are implied, presumed, rather than actual, express. A legal process can be defective in law. This accords with the previous discussions of legal fictions and color of law. To be legal, a matter does not have to follow the law. Instead, it conforms to and follows the rules or form of law. This is why the federal and state rules of civil and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic persons named, example State of Georgia or the U.S. federal government that rule the courts. Lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the organic constitution has no bearing or authority in the present-day legal courts. It is impossible for anyone in authority today to access, or even take cognizance of, true law since authority is the law of necessity, 12 U.S.C. 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary, 5th edition, defines as color of law. The appearance or semblance, without the substance, of legal right. Misuse of power, possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Black's Law Dictionary, 5th ed., pg 241. Executive orders rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevails instead of actual law. This takes place on a federal as well as state level. Government administrates what it has created through its own purported laws, which are not lawful, but merely legal. They are arbitrary constructs existing only because of the actions of people acting on fictitious, self-created, authority, i.e. no authority. They are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census 2000 reveals that the legal authority for the census comes from Office of Management and Budget, 0 megabytes, approval no 0607-0856. The 0 megabytes is a part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economics and Statistics Administration of the U.S. Department of Commerce, USDOC. The USDOC is a department of the executive branch. Obviously, Census 2000 is authorized, carried out, controlled, enforced and implemented by the President, the executive branch of the federal government, functioning as it has been since 1861, in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the President controls the entire nation through various departments and agencies affecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more, through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for these executive orders on Article 2, Section 2 of the Constitution for the United States of America, 1764 to date. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the United States. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers, as they think proper, in the President alone, in the courts of law, or in the heads of departments. In reality, the Congress is completely bypassed. Since the Senate was convened in April 1861 by Presidential Executive Order No. 2, not by lawful constitutional due process, there is no United States Congress. The current Senate and House are, like everything, colorable, color of Senate, under the direct authority of the executive office of the President. The President legally needs neither the consent nor a vote from the Senate simply because the Senate's legal authority to meet exists only by executive order. Ambassadors, public ministers, consuls, federal judges, and all officers of the United States are appointed by, and under authority of, the executive office of the President. The Federal Registry is an executive function. The first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, and the Amendatory Act of March 9, 1933, the Banking Relief Act. In the Amendatory Act, every citizen of the United States was made an enemy of the government, i.e. the Federal Reserve/IMF, et al., creditors in bankruptcy who have conquered the country by their great paper money banking swindle. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register, OFR. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is found within the United States Code, Title 44, at Chapter 15, 1506. Administrative Committee of the Federal Register, Establishment and Composition, Powers and Duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or Acting Archivist, who shall be Chairman, an officer of the Department of Justice designated by the Attorney General, and the Public Printer or Acting Public Printer. The Director of the Federal Register shall act as Secretary of the Committee. The Committee shall prescribe, with the approval of the President, regulations for carrying out this chapter. Notice that the entire Administrative Committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The President does. This act also gives the President the authority to decree all the regulations to carry out the act. By this monopoly the executive establishes, controls, regulates, and enforces the federal government without need for any approval from the Senate or anyone else, other than his undisclosed superiors. He operates without any accountability to the people at all. How can this be considered lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm United States vessels traversing hostile German waters before the United States entered World War I, so Wilson simply invoked the policy through a presidential executive order. President Franklin D. Roosevelt issued Executive Order No. 9066 in December 1941 forcing 100,000 Americans of Japanese descent to be rounded up and placed in concentration camps while all their property was confiscated. Is it any wonder that the Congress, which the President legally controls, did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming? On that note, why is it that attorney presidents have used executive orders the most? Who, but an attorney, would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful since the entirety of their authority, which is ethically and existentially specious, derives from the war powers. How debt is assumed by legal fictions. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrarily created juristic persons, e.g. State of California or John P. Jones. Since an assumption, by definition, implies debt, what debt does a legal fiction assume? Now that we have explored the legal, executive, basis of the current federal and state governments, it's time to put all this together. The government use of all caps in place of proper names is absolutely no mistake. It signifies an internal, legal, rule and authority. Its foundation is pure artifice and the results have compounded into more deceit in the form of created, promulgated, instituted, administered, and enforced rules, codes, statutes, and policy, i.e. the laws that appear to be but are not, never were, and never can be. Qui senti commodum, sentire debet et onus. He who enjoys the benefit, ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage, a privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments, themselves specially created, juristic, corporate persons signified by all caps, have issued birth certificates to persons with legal fiction all caps names. This is not a lawful record of your physical birth, but rather the birth of the juristic, all caps name. It may appear to be your true name, but since no proper name is ever written in all caps, either lawfully or grammatically, it does not identify who you are. The birth certificate is the government's self-created document of title for its new property, i.e. the deed to the juristic name artificial person whose all caps name mirrors your true name. The birth certificate brings the new all caps name into colorable admiralty/maritime law, the same way a ship, and ship of state, is birthed. One important area to address, before going any further, is the governmental use of older data storage from the late 1950s until the early 1980s. As a leftover from various teletype-oriented systems, many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps, when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, and birth certificates and other important documents, such as driver's licenses, were produced with typewriters, it's very doubtful that this poses much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older databank all caps storage systems would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. Automated computer systems, with daisy wheel and pin printers used prevalently in the early 1980s, emulated the IBM Electric Typewriter Courier or Helvetica fonts in both upper and lower case letters. Shortly thereafter, the introduction of laser and inkjet printers with multiple fonts became the standard. For the past 15 years, there is no excuse that the government computers will not accommodate the use of lowercase letters unless the older data is still stored in its original form, i.e. all caps, and has not been translated due to the costs of re-entry. But this does not excuse the entry of new data, only legacy data. In fact, on many government forms today, proper names are in all caps while other areas of the same computer-produced document are in both upper and lower case. One can only conclude that now, more than ever, the use of all caps in substitution the writing a proper name is no mistake. When a child is born, the hospital sends the original, not a copy, of the record of live birth to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Services, HRS. Each state is required to supply the United States with birth, death, and health statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted, all caps version of the baby's true name, i.e. James Wilbur Smith. Certificate, noun. Middle English certificat, from Middle French, from Medieval Latin certificatum. From Late Latin, neuter of certificatus, past participle of certificare, to certify, 15th century. 3. A document evidencing ownership or debt. Merriam-Webster Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the executive office specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all caps legal person named thereon has become a surety or guarantor, a condition, an obligation that is automatically and unwittingly assumed unless you rebut the presumption by effectively noticing them, it ain't me. Registered. Security, bond. Merriam-Webster Dictionary of Law, 1996. Security. I.A. Something, as a mortgage or collateral, that is provided to make certain the fulfillment of an obligation. Example, used his property as security for a loan. Surety. 2. Evidence of indebtedness, ownership, or the right to ownership. Bond. I.A. A usually formal written agreement by which a person undertakes to perform a certain act, as fulfill the obligations of a contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person or surety. 1b. One who acts as a surety. 2. An interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. IBID. Surety. The person who has pledged him or herself to pay back money or perform a certain action if the principal to a contract fails, as collateral, and as part of the original contract. Duimes. Law Dictionary. 1. A formal engagement, as a pledge, given for the fulfillment of an undertaking. 2. One who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor, and the two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor. A person who pledges collateral for the contract of another, but separately, as part of an independently contract with the obligee of the original contract. Duimes Law Dictionary. It is not difficult to see that a state-created birth certificate, with an all caps, name is a document evidencing debt the moment it is issued. Once a state has registered a birth document with the U.S. Department of Commerce, the department notifies the Treasury Department, which takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. The Fed holds a purchase money security interest in the bond, from the Department of Commerce, which invests the sale proceeds in the stock or bond market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, and bills using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that the bankrupt, corporate U.S. can guarantee to the purchasers of their securities the lifetime labor and tax revenues of every citizen of the United States/American with a birth certificate as collateral for payment. This device is initiated simply by converting the lawful, true name of the child into a legal, juristic name of a person. Dubuque rei poticinia pars praeniapium est. The principal part of everything is in the beginning. Well begun is half done. Legally, you are considered to be a slave or indentured servant to the various federal, state, and local governments via a Department of Health owned, state-issued and state-created birth certificate in the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license or a social security account number. The state even owns your personal and private life through your state-issued marriage license/certificate issued in the all-caps names. You have no rights in birth, marriage, or even death. The state holds title to all legal persons the state creates via birth certificates until the rightful owner, i.e. you, reclaims/redeems it by becoming the holder in due course of the instrument. The main problem is that the mother and father, and then the 18-year-old man or woman, voluntarily agreed to this contrived system of plunder and slavery by remaining silent, a legal default, laches, and failing to claim one's own rights. The maxim of law becomes crucially operative: he who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Government rules are self-regulating and self-supporting. Once set into motion, such laws automatically come into effect provided the legal process has been followed. The various bankruptcies. The juristic, legal person known as the United States is bankrupt and withholds all lawful and constitutionally mandated silver or gold coin or bullion, with which to back any currency. All private held and federally held gold coins and bullion in America was seized via executive order of April 5, 1933 and paid to the creditor, the private Federal Reserve Corporation under the terms of the bankruptcy. Congress, still convening strictly under executive order authority, confirmed the bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5, 1933, House Joint Resolution, HJR, 192, June 5, 1933, 73rd Congress, First Session, Public Law 73-10. This 1933 Public Law states, in part, every provision contained in or made with respect to any obligation which purports to give the obliger right to require payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy. The corporate U.S. declared bankruptcy a second time, whereby the Secretary of Treasury was appointed receiver for the bankrupt U.S. in Reorganization Plan No. 26, Title 5 U.S.C. 903, Public Law 94-564, Legislative History, page 5967. Since 1933, the only assets used by the United States to pay its debt to the Fed have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and a Social Security account number. The U.S. government must conceal this fact from the American people at all cost. Their future labor and tax revenues have been legally pledged via the new all caps, juristic person names appearing on the birth certificates, i.e. the securities used as collateral for loans of credit, thin air belief, to pay daily operational costs, reorganization expenses in bankruptcy, insurance policy premiums required to float the bankrupt government, and interest on the ever-increasing, wholly fraudulent, debt. All caps legal person vs. the lawful being. Just who or what is the all caps person, i.e. John Paul Jones, John P. Jones, or some other all capital letter corruption thereof? It is the entity the government created to take the place of the real being, i.e. John Paul Jones. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers as the legal person, the two are recognized as being one and the same. However, if the lawful being distinguishes himself/herself as a party other than the legal fiction, the two are separated. A result of the federal bankruptcy was the creation of the United States, which was made a part of the legal reorganization. The name of each state was also converted to its respective, all caps, and juristic, legal person, e.g. State of Delaware. These new juristic, legal persons were then used to create more legal persons, such as corporations, with all capital letters names, as well. Once this was accomplished, the greed quickly picked up speed. All areas of government and all alleged courts of law are de facto, color of law and right institutions. The Circuit Court of Wayne County and the U.S. District Court can recognize and deal only with other legal persons. This is why a lawful name is never entered in their records. The all caps juristic, legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned, common law venue court. Unfortunately, such jurisdiction was shelved in 1938 and is no longer available to most. Most all courts today are statutory commercial tribunals collecting tribute, plunder, from the alleged creditors who think they have conquered the country on their way to ruling the world. The Organic versus Corporate United States of America. 1871 District of Columbia Organic Act. The Subfranchises of Corporate America. The 14th Amendment. Citizen. The newly created Corporate U. How you have become the surety the corporations doing business together. How it works and is enforced. Real de jure America. Sovereign, protect and serve, ruler of self. Corporate USA Corp. U. Vital statistics. Juristic, for profit and in business person. Now to bring this section home, I would like for you to see this court case. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc. can concern itself with anything other than corporate, artificial persons and the contracts between them. SCR 1795, Penelau v. Dones Administrators, 3 U.S. 54, 1 L.ed 57, 3 Dol 54. 2 Definitions and cases with their proper usage. Now for some key definitions used in commercial law. For those of you who believe that a person is you and not a corporation, or that the USA is not a corporation. Now to point out the thoughts and understanding from the American Bar Association. In their book entitled The New Article 9 Uniform Commercial Code 2nd edition, copyright 2000. In the preface to the first edition. Page #7. The first sentence reads, I never thought that I would read a statute that reports, the United States is located in the District of Columbia. With this in mind, please read on. Person, term may include artificial beings, as corporations, it may include partnerships. Persons are 2 kinds, natural and artificial. A sovereign is not a person. United Mine Workers versus United States, 330 U.S. 258. Person. It may include limited to artificial beings, as corporations, territorial corporations, foreign corporations, relating to taxation and revenue laws. 14 Amendment persons. A county, a slave, estate of a decedent, a judge holding court, an infant ward of the court, officers, partnerships, and women, participants in the Forbidden Acts, defendants and plaintiffs, agents, officers, and members of the board of directors or trustees, or their controlling bodies, of corporations, the legal subject matter or substance rem, res, Bouvier's Law Dictionary, 8th ed., PG 2574. 5 U.S.C. 552, A, 2, for term individual, 2, the term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. 5 U.S.C. 552A, A, 13, for definition of federal personnel. The term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Now let's look at people from Bouvier's dictionary. People. A state, as, the people of the state of New York, a nation in its collective and political capacity. 4 TR 783. C6 Pet SC Republic 467. Juristic, pertaining to or belonging to, or characteristic of. Surety, one who undertakes to pay. Being bound for another. Straw man, as defined in Black's Law Dictionary, 6th edition, affront, a third party who is put up in name only to take part in a transaction. Nominal party to a transaction, one who acts as an agent for another for the purpose of taking title to real property and executing whatever documents and instruments the principal may direct respecting the property. Person who purchases property for another to conceal identity of real purchaser or to accomplish some purpose otherwise not allowed. Emphasis added. Now for the UCC code itself. You first must know some definitions. Understanding what the words factually mean is the whole key to the code. Article 9 to 102. BB, debtor means one of the following. I, a person having an interest, other than a security interest or other lien, in the collateral, whether or not the person is an obliger. Sounds like the owner to me. 2. A seller of accounts, chattel paper, payment intangibles, or promissory notes. 3. A consignee. SSS, secured party means one or more of the following. I, a person in whose favor a security interest is created or provided for under a security agreement, whether or not any obligation to be secured is outstanding. 2. A person that holds an agricultural lien. 3. A consignor. 4. A person to which accounts, chattel paper, payment intangibles, or promissory notes have been sold. V. A trustee, indenture trustee, agent, collateral agent, or other representative in whose favor a security interest or agricultural lien is created or provided for. 6. A person that holds a security interest arising under Section 2401, 2505, 2711, 3, 2A508, 5, 4210, or 5118. UU, instrument means a negotiable instrument or any other writing that evidences a right to the payment of a monetary obligation, is not itself a security agreement or lease, and is of a type that in ordinary course of business is transferred by delivery with any necessary endorsement or assignment. The term does not include investment property, letters of credit, or writings that evidence a right to payment arising out of the use of a credit or charge card or information contained on or for use with the card. 73. To comply with a statute or regulation described in subsection B, has only, security agreement means an agreement that creates or provides for a security interest. In case of conflict between this article and a rule of law, statute, or regulation described in subsection B, the rule of law, statute, or regulation controls. Failure the effect the statute or regulation specifies. 76. State means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. 45. Governmental unit means a subdivision, agency, department, county, parish, municipality, or other unit of the government of the United States, a state, or a foreign country. The term includes an organization having a separate corporate existence if the organization is eligible to issue debt on which interest is exempt from income taxation under the laws of the United States. Article 3 to 104. 7. Draft means a draft as defined in Section 3 to 104 or an item, other than an instrument, that is an order. Article 8 to 102. A. Adverse claim means a claim that a claimant has a property interest in a financial asset and that it is a violation of the rights of the claimant for another person to hold, transfer, or deal with the financial asset. C. Broker means a person defined as a broker or dealer under the federal securities laws, but without excluding a bank acting in that capacity. G. Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary. If a person acquires a security entitlement under Section 8501, 2, b, or c, that person is the entitlement holder. N. Securities intermediary means either of the following. I. A clearing corporation. 2. A person, including a bank or broker, that in the ordinary course of its business maintains securities accounts for others and is acting in that capacity. O. Security, except as otherwise provided in Section 8103, means an obligation of an issuer or a share, participation, or other interest in an issuer or in property or an enterprise of an issuer and is all of the following. Article 1 to 201. 3. Agreement means the bargain of the parties in fact as found in their language or by implication from other circumstances including course of dealing or usage of trade or course of performance as provided in this Act, Sections 1 to 205 and 2 to 208. Whether an agreement has legal consequences is determined by the provisions of this Act, if applicable, otherwise by the law of contracts, Section 1 to 103. Compare contract. 11. Contract means the total legal obligation which results from the parties' agreement as affected by this Act and any other applicable rules of law. Compare agreement. 16. Fault means wrongful act, omission, or breach. 18. Genuine means free of forgery or counterfeiting. 19. Good faith means honesty in fact in the conduct or transaction concerned. See 1 to 103 in contract above. 39. Signed includes any symbol executed or adopted by a party with present intention to authenticate a writing, including a carbon copy of his or her signature. 40. Surety includes guarantor. Article 8 to 103. 4. A writing that is a security certificate is governed by this article and not by Article 3, even though it also meets the requirements of that article. However, a negotiable instrument governed by Article 3 is a financial asset if it is held in a securities account. 5. An option or similar obligation issued by a clearing corporation to its participants is not a security, but is a financial asset. Article 3 to 105. Issue and issuer defined, effect of unissued or conditionally issued instrument. 1. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. Article 3 to 103. 5. Drawer means a person who signs or is identified in a draft as a person ordering payment. Is this you or the bank? If you are not there signing, who orders anything? 7. Maker means a person who signs or is identified in a note as a person undertaking to pay. Is this you or the bank? Who really issued the instrument? 4 to 104. 8. Drawee means a person ordered in a draft to make payment, bank. Keep these definitions close by. They may come in pretty handy and will definitely let most know you are not the average mind. Tertius interveniens. Lat. In the civil law, a third person intervening, a third person who comes in between the parties to a suit, one who interpleads. Real party in interest. Person who will be entitled to benefits of action if successful, that is, the one who is actually and substantially interested in subject matter as distinguished from one who has only a nominal, formal, or technical interest in or connection with it. Maryland Co. Co v. King, Oakle, 381 p.2d. 153, 156. Under the traditional test, a party is a real party in interest if it has the legal right under the applicable substantive law to enforce the claim in question. Whitehall Building Corp v. Prof. X-Ray Division of Litton Industries Incorporated, D.C.Pa, 387 f.sup. 1202, 1204. Real party in interest within rule that every civil action in federal courts must be prosecuted in name of real party in interest is the one, who, under applicable substantive law, has legal right to bring suit. Boeing Airplane Co. v. Perry, C.A. Kansas, 322 f.2d 589, 591, and not necessarily person who will ultimately benefit from the recovery. First Nat Bank of Chicago v. Motola, D.C.Il, 302 f.sup. 785, 791, 792. See Federal R. Civil p. 17. Intervenor. An intervenor is a person who voluntarily interposes in an action or other proceeding with the leave of the court. See intervention. Bouvier's Law Dictionary defines the United States as, the territory of which these states are composed was at one time dependent generally on the Crown of Great Britain, though governed by the local legislatures of the country. It is not within the plan of this work to give a history of the colonies. On this subject the reader is referred to Kent's Commander Section 10, Story on the Constitution, Book 1, 8 Wheat. Republic 543, Marshall, History: The United States of America are a corporation endowed with the capacity to sue and be sued, to convey and receive property. 1 Marsh. December 177, 181. But it is proper to observe that no suit can be brought against the United States without authority of law. In monetary suits et. Title 28, Judiciary and Judicial Procedure Part 6, Particular Proceedings, Chapter 176, Federal Debt Collection Procedure Subchapter A, Definitions and General Provisions, most all cases again deal in monetary suits right. See 27 CFR 72.11. Sector 3002. Definitions. 15. United States means a. A federal corporation. b. An agency, department, commission, board, or other entity of the United States, or c. An instrumentality of the United States. This would include states, counties, and cities. 19 CJS 18. Foreign Corporations A 883. The very last sentence reads, the United States government is a foreign corporation with respect to a state. It goes on further to read, rather, it must dwell in the place of its creation, and cannot migrate to another sovereignty. Now what do the courts say about this? United States government is a foreign corporation with respect to a state of the Union in Re Merriam's Estate, 36 NE 505, 141 NY 479, affirmed 16 SCT, 1073, 41 L.ed. 287. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc. can concern itself with anything other than corporate, artificial persons and the contracts between them. SCR 1795, Penelau v. Dones Administrators, 3 U.S. 54, 1 L.ed 57, 3 Dol 54. Cases: Juristic Person. 1 Find Law, United States v. Cooper Corporation, 312 U.S. 600, 1941, http://laws.findlaw.com/a/312/600.html shall recover threefold the damages by him sustained, and the costs of suit, including a reasonable attorney's fee. The United States is a juristic person in the sense that it has capacity to sue upon contracts made with it or in vindication of its property rights. The Sherman Act, however, created new. 2 Find Law, U.S. v. Scoffany Corp. of America, 333 U.S. 795, 1948, http://laws.findlaw.com/a/333/795.html enforce its rights. See example Promthanath Mullik v. Pradyumnakumar Mullik, 52 LRIA 245, 1925. Attribution of legal rights and duties to a juristic person other than man is necessarily a metaphorical process. And none the worse for it. No doubt, metaphors in law are to be narrowly watched. Cardozo. 3 Find Law, Hopkins Federal Savings and Loan Association v. Cleary, 296 U.S. 315, 1935, http://laws.findlaw.com/a/296/315.html. Also to put an end to corporations created by the states and turn them into different corporations created by the nation. A corporation is a juristic person organized by government to accomplish certain ends, which may be public or quasi-public, though for other purposes of classification the corporation. 4 Find Law, Clark v. Williard, 292 U.S. 112, 1934, http://laws.findlaw.com/a/292/112.html. Bankruptcy or insolvency proceedings, whether the debtor is a natural or a juristic person, confer upon the receiver or assignee a title which, generally speaking, is without recognition outside of the state of his appointment except in subordination to the claims of local creditors. Security Trust Co. v. Dodd, Mead & Co., 173 U.S. 624, 19 S.Ct. 545. 5. Find Law, United States v. Candelaria, 271 U.S. 432, 1926, http://laws.findlaw.com/a/271/432.html. It was settled in Lane v. Pueblo of Santa Rosa, 249. U.S. 110, 39 SCT 185, that under territorial laws enacted with congressional sanction each pueblo in New Mexico, meaning the Indians comprising the community, became a juristic person and enabled to sue and defend in respect of 271 U.S. 432, 443 its lands. 6. Find Law, Lane v. Pueblo of Santa Rosa, 249 U.S. 110, 1919, http://laws.findlaw.com/a/249/110.html. If the plaintiff was not a legal entity and juristic person before, it became such under that law, and it retained that status after Congress included it in the territory of Arizona, for the act by which this was done extended to that territory all legislative enactments of the territory of New Mexico. Act February 24, 1863, C-56, 12 Stat 664. The fact that Arizona has since become a state does not affect the plaintiff's corporate status or its power to sue. See Kansas Pacific R.R. Co. v. Atchison, Topeka and Santa Fe R.R. Co., 112 U.S. 414, 5 Sup. CT 208. 7. Find Law, Vilas v. City of Manila, 220 U.S. 345, 1911. http://laws.findlaw.com/a/220/345.html. Upon the theory that the city, under its present charter from the government of the Philippine Islands, is the same juristic person and liable upon the obligations of the old city, these actions were brought against it. The city as now incorporated has succeeded to all of the property rights of the old city and to the right to enforce all of its causes of action. There is identity of purpose between the Spanish and American charters and substantial identity of municipal powers. The area and the inhabitants incorporated are substantially the same. But for the change of sovereignty which has occurred under the Treaty of Paris, the question of the liability of the city under its new charter for the debts of the old city would seem to be of easy solution. And so the question was made to turn in the court below upon the consequence of a change in sovereignty and a reincorporation of the city by the substituted sovereignty. 8. United States v. Scoffany Corporation of America et al. No. 41, Supreme Court of the United States, 333 U.S. 795, 68 SCT 855, 1948 U.S. Lexus 2851, 92 L. ed. 1091, 77. USPQ. From the earliest times the law has enforced rights and exacted liabilities by utilizing a corporate concept by juristic persons other than human beings. Law has also responded to religious needs in recognizing juristic persons other than human beings. Attribution of legal rights and duties to a juristic person other than a man is necessarily a metaphorical process. 9. United States v. Cooper Corporation et al. No. 484 Supreme Court of the United States, 312 U.S. 600, 61 SCT 742, 1941 U.S. Lexus 1088, 85 L. ed. 1071. While the United States is a juristic person in the sense that it can sue upon its contracts or in a vindication of its property rights, the term person does not include the sovereign, in common usage, nor, ordinarily, when employed in statutes. 11. United States v. Candelaria et al., No. 208 Supreme Court of the United States, 271 U.S. 432, 46 SCT 561, 1926 U.S. Lexus 633, 70 L. ed. 1023. Under territorial laws, sanctioned by Congress, a Pueblo community in New Mexico is a juristic person with capacity to sue and defend with respect to its lands. 12. Hopkins v. Clemson Agricultural College of South Carolina No. 70 Supreme Court of the United States, 221 U.S. 636, 31 SCT 654, 1911 U.S. Lexus 1762, 55 L. ed. 890. On the contrary, the statute created an entity, a corporation, a juristic person, whose right to hold and sue property was coupled with the provision that it might sue and be sued, plead and be impleaded, in its corporate name. Now I think it is proven by American jurisprudence, case law, code sections, common sense, and statute and the UCC, complete transparency, that the USA is a corporation and you, unless proven sovereign, are a corporation doing business with the corporate USA. Now this sheds light on how they can say they are the sovereign. They are the sovereign of the corporate USA because they created it. However, is this really who you are? Is this really who the US government is, according to what they make you believe? Try looking at this a different way. Please make sure to read Federalist Paper number 10 Republic vs. Democracy and then think of how many run to vote and then ask yourself what are you voting for? The two names this election are two that you nor any other Republican had anything to do with in picking of the two cousins, Bush and Kerry, in part Republic vs. Democracy, it reads. From this view of the subject it may be concluded that a pure democracy, by which I mean a society consisting of a small number of citizens, who assemble and administer the government in person, can admit of no cure for the mischiefs of faction. A common passion or interest will, in almost every case, be felt by a majority of the whole, a communication and concert result from the form of government itself, and there is nothing to check the inducements to sacrifice the weaker party or an obnoxious individual. Hence it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. Theoretic politicians, who have patronized this species of government, have erroneously supposed that by reducing mankind to a perfect equality in their political rights, they would, at the same time, be perfectly equalized and assimilated in their possessions, their opinions, and their passions. A republic, by which I mean a government in which the scheme of representation takes place, opens a different prospect, and promises the cure for which we are seeking. Let us examine the points in which it varies from pure democracy, and we shall comprehend both the nature of the cure and the efficacy which it must derive from the union. The two great points of difference between a democracy and a republic are, first, the delegation of the government, in the latter, to a small number of citizens elected by the rest, secondly, the greater number of citizens, and greater sphere of country, over which the latter may be extended. The effect of the first difference is, on the one hand, to refine and enlarge the public views, by passing them through the medium of a chosen body of citizens, whose wisdom may best discern the true interest of their country, and whose patriotism and love of justice will be least likely to sacrifice it to temporary or partial considerations. Under such a regulation, it may well happen that the public voice, pronounced by the representatives of the people, will be more consonant to the public good than if pronounced by the people themselves, convened for the purpose. On the other hand, the effect may be inverted. Men of factious tempers, of local prejudices, or of sinister designs, may, by intrigue, by corruption, or by other means, first obtain the suffrages, and then betray the interests, of the people. The question resulting is, whether small or extensive republics are more favorable to the election of proper guardians of the public will, and it is clearly decided in favor of the latter by two obvious considerations. In the first place, it is to be remarked that, however small the republic may be, the representatives must be raised to a certain number, in order to guard against the cabals of a few, and that, however large it may be, they must be limited to a certain number, in order to guard against the confusion of a multitude. Hence, the number of representatives in the two cases not being in proportion to that of the two constituents, and being proportionally greater in the small republic, it follows that, if the proportion of fit characters be not less in the large than in the small republic, the former will present a greater option, and consequently a greater probability of a fit choice. In the next place, as each representative will be chosen by a greater number of citizens in the large than in the small republic, it will be more difficult for unworthy candidates to practice with success the vicious arts by which elections are too often carried, and the suffrages of the people being more free, will be more likely to center in men who possess the most attractive merit and the most diffusive and established characters. It must be confessed that in this, as in most other cases, there is a mean, on both sides of which inconveniences will be found to lie. By enlarging too much the number of electors, you render the representatives too little acquainted with all their local circumstances and lesser interests, as by reducing it too much, you render him unduly attached to these and too little fit to comprehend and pursue great and national objects. The federal constitution forms a happy combination in this respect, the great and aggregate interests being referred to the national, the local, and particular to the state legislatures. The other point of difference is, the greater number of citizens and extent of territory which may be brought within the compass of republican than of democratic government, and it is this circumstance principally which renders factious combinations less to be dreaded in the former than in the latter. The smaller the society, the fewer probably will be the distinct parties and interests composing it, the fewer the distinct parties and interests, the more frequently will a majority be found of the same party, and the smaller the number of individuals composing a majority, and the smaller the compass within which they are placed, the more easily will they concert and execute their plans of oppression. Extend the sphere, and you take in a greater variety of parties and interests, you make it less probable that a majority of the whole will have a common motive to invade the rights of other citizens, or if such a common motive exists, it will be more difficult for all who feel it to discover their own strength, and to act in unison with each other. Besides other impediments, it may be remarked that, where there is a consciousness of unjust or dishonorable purposes, communication is always checked by distrust in proportion to the number whose concurrence is necessary. Hence, it clearly appears, that the same advantage which a republic has over a democracy, in controlling the effects of faction, is enjoyed by a large over a small republic is enjoyed by the Union over the states composing it. Does the advantage consist in the substitution of representatives whose enlightened views and virtuous sentiments render them superior to local prejudices and schemes of injustice? It will not be denied that the representation of the Union will be most likely to possess these requisite endowments. Does it consist in the greater security afforded by a greater variety of parties, against the event of any one party being able to outnumber and oppress the rest? In an equal degree does the increased variety of parties comprised within the Union, increase this security. Does it, in fine, consist in the greater obstacles opposed to the concert and accomplishment of the secret wishes of an unjust and interested majority? Here, again, the extent of the Union gives it the most palpable advantage. A rage for paper money, for an abolition of debts, for an equal division of property, or for any other improper or wicked project, will be less apt to pervade the whole body of the Union than a particular member of it, in the same proportion as such a malady is more likely to taint a particular county or district, than an entire state. In the extent and proper structure of the Union, therefore, we behold a republican remedy for the diseases most incident to republican government. And according to the degree of pleasure and pride we feel in being republicans, ought to be our zeal in cherishing the spirit and supporting the character of Federalists. 3. Law, contracts, and consent. Do we have law or a contract? Or is law the contract? After reading this entire section, please come back to this paragraph and read it again and see your thoughts, and then really read this paragraph. This I hope will also allow you understand what is meant by really reading something. Quote from the ABA Revised Article 9. A person obligated on a negotiable instrument, such as a maker or indexer, when notified to pay a transferee of the instrument, and under UCC Article 3 require the transferee to exhibit the instrument in order to demonstrate that the transferee is the person entitled to enforce the instrument 3-501, b. 2, and 3-602, a. Revised Article 9 does not change this rule, nor does it explain whether a non-negotiable instrument must be exhibited by the transferee as a condition to payment by the obligated person. Under Bouvier's Law Dictionary we find law to read, law. In its most general and comprehensive sense, law signifies a rule of action, and this term is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. 1 BL Commander 38. In its more confined sense, law denotes the rule, not of actions in general, but of human action or conduct. In the Civil Code of Louisiana, Art. 1, it is defined to be a solemn expression of the legislative will. Vide Towel. Dr. Civ Father Tit. Prol. S1, N4, 1 Bov. INSTN 1-3. Now after reading this, is it not true that the rule is the very agreement and contract that was signed by the two parties? Also keep in mind that all sales are governed by Article 2. Sales and leases. See 2-401. Inside the new revised Article 9, a book written by the American Bar, it reads Scope, Accounts. Article 9 has always applied to the sale of account. Revised Article 9 continues this rule. Notice how the word sale was used. This means if there was no sale there is no contract. No, for most folks you would think, well, since I got my yard supplies at Home Depot there was a sale. However, if you used a credit card at Home Depot, where was the sale between you and the credit card? Where did the credit card get its money to pay Home Depot if it is a federal violation for them to use their own capital stock or use their own money? The biggest question here is not the merchant sale, it's the sale between you and the credit card company. Now ask yourself, if there was no sale there, how can there be any interest, let alone any attachment? Article 2 of the UCC covers sales, and let's see the section regarding sales and what sales are regulated under. 2 to 106. Definitions: contract, agreement, contract for sale, sale, present sale, conforming to contract, termination, cancellation. 1. In this article, unless the context otherwise requires, contract and agreement are limited to those relating to the present or future sale of goods. Contract for sale includes both a present sale of goods and a contract to sell goods at a future time. A sale consists in the passing of title from the seller to the buyer for a price, section 2 to 401. A present sale means a sale which is accomplished by the making of the contract. 2. Goods or conduct including any part of a performance are conforming or conform to the contract when they are in accordance with the obligations under the contract. 3. Termination occurs when either party pursuant to a power created by agreement or law puts an end to the contract otherwise than for its breach. On termination, all obligations which are still executory on both sides are discharged, but any right based on prior breach or performance survives. 4. Cancellation occurs when either party puts an end to the contract for breach by the other, and its effect is the same as that of termination, except that the cancelling party also retains any remedy for breach of the whole contract or any unperformed balance. 2 to 401. Passing of title, reservation for security, limited application of this section. Each provision of this article with regard to the rights, obligations, and remedies of the seller, the buyer, purchasers or other third parties applies irrespective of title to the goods, except where the provision refers to such title. Insofar as situations are not covered by the other provisions of this article and matters concerning title become material, the following rules apply. 1. Title to goods cannot pass under a contract for sale prior to their identification to the contract, section 2 to 501, and unless otherwise explicitly agreed, the buyer acquires by their identification a special property as limited by this act. Any retention or reservation by the seller of the title, property, in goods shipped or delivered to the buyer is limited in effect to a reservation of a security interest. Subject to these provisions and to the provisions of the article on secured transactions, Article 9, title to goods passes from the seller to the buyer in any manner and on any conditions explicitly agreed on by the parties. 4. A rejection or other refusal by the buyer to receive or retain the goods, whether or not justified, or a justified revocation of acceptance reviests title to the goods in the seller. Such revesting occurs by operation of law and is not a sale. 2 to 201. Formal requirements, Statute of Frauds. 1. Except as otherwise provided in this section, a contract for the sale of goods for the price of $500 or more is not enforceable by way of action or defense unless there is some writing sufficient to indicate that a contract for sale has been made between the parties and signed by the party against whom enforcement is sought or by his authorized agent or broker. A writing is not insufficient because it omits or incorrectly states a term agreed upon, but the contract is not enforceable under this paragraph beyond the quantity of goods shown in such writing. B. If the party against whom enforcement is sought admits in his pleading, testimony, or otherwise in court that a contract for sale was made, but the contract is not enforceable under this provision beyond the quantity of goods admitted, or 2 to 206. Offer and acceptance in formation of contract. 1. Unless otherwise unambiguously indicated by the language or circumstances. A. An offer to make a contract shall be construed as inviting acceptance in any manner and by any medium reasonable in the circumstances. B. An order or other offer to buy goods for prompt or current shipment shall be construed as inviting acceptance either by a prompt promise to ship or by the prompt or current shipment of conforming or non-conforming goods, but such a shipment of non-conforming goods does not constitute an acceptance if the seller seasonably notifies the buyer that the shipment is offered only as an accommodation to the buyer. 2. Where the beginning of a requested performance is a reasonable mode of acceptance, an offerer who is not notified of acceptance within a reasonable time may treat the offer as having lapsed before acceptance. 2 to 301. General obligations of parties. The obligation of the seller is to transfer and deliver, and that of the buyer is to accept and pay in accordance with the contract. What governs the contract? 2 to 302. Unconscionable contract or clause. 1. If the court as a matter of law finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. 2. When it is claimed or appears to the court that the contract or any clause thereof may be unconscionable, the parties shall be afforded a reasonable opportunity to present evidence as to its commercial setting, purpose, and effect to aid the court in making the determination. Now for the signature part of this. There are 2 sections below relating to signature. One is under the general provision of Article 1 and the other falls under Article 3 with negotiable instruments. 1 to 201. General definitions. 39. Signed includes any symbol executed or adopted by a party with present intention to authenticate a writing. 3 to 401. Signature. A. A person is not liable on an instrument unless, I. The person signed the instrument, or, 2. The person is represented by an agent or representative who signed the instrument and the signature is binding on the represented person under Section 3 to 402. B. A signature may be made, I. Manually or by means of a device or machine, and, 2. By the use of any name, including a trade or assumed name, or by a word, mark, or symbol executed or adopted by a person with present intention to authenticate a writing. Notice the only thing required is intent of authentication. Would this not be the very acknowledgement of the agreement itself? Think about this one. Before you get too far into the section, you must understand the foundation of commercial law. As long as good faith is present, there is a claim. However, if good faith is not present, no contract exists. Page 58 of the revised Article 9 reads: the definition of good faith in current Article 9 is the UCC Article 1 definition, honesty in fact. 1-201, 19. Consistent with revisions to other UCC articles, revised Article 9 has its own definition of good faith, including honesty in fact and the observance of reasonable commercial standards of fair dealing. Rev 9102. A. 43. Now for some specific section in the UCC regarding good faith. 1 to 102. Purposes, rules of construction, variation by agreement. 1. This act shall be liberally construed and applied to promote its underlying purposes and policies. 2. Underlying purposes and policies of this act are: A. To simplify, clarify, and modernize the law governing commercial transactions. B. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. C. To make uniform the law among the various jurisdictions. 3. The effect of provisions of this act may be varied by agreement, except as otherwise provided in this act, and except that the obligations of good faith, diligence, reasonableness, and care prescribed by this act may not be disclaimed by agreement, but the parties may by agreement determine the standards by which the performance of such obligations is to be measured if such standards are not manifestly unreasonable. 4. The presence in certain provisions of this act of the words "unless otherwise agreed" or words of similar import does not imply that the effect of other provisions may not be varied by